Some litigation attracts media attention, whether it's a high-profile criminal prosecution or a major civil case like mass tort litigation or lawsuits involving celebrities. The lawyers involved in litigation sometimes make statements to the media. This could be a passing comment to reporters outside the courthouse, or maybe they could do an interview on television or radio or on someone's podcast. Some lawyers, in fact, actually seek out publicity for their cases or try to attract media attention in hopes of helping their client's case, or at least to try to repair the damage done to their client's reputation by the media coverage of the litigation. We have a rule that governs such media statements by lawyers involved in litigation, and that's Model Rule 3.6. As you might imagine, lawyers disciplined under this rule have brought First Amendment challenges, free speech, to the rule's restrictions on what lawyers can say. And in one of these early cases, the U.S. Supreme Court ended up forcing the rule to be changed. And those changes are reflected in the current version of Rule 3.6. I'm not going to go through all those cases, but you should be aware that a number of challenges have been brought to this rule over the years under the First Amendment. So let's dive in. Rule 3.6a says, a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication, and that will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Now, this is a pretty convoluted way of saying you can't make statements to the media that are likely to impact the proceedings, whether by influencing the jury pool or creating public pressure on the judge. Notice that there are some hedge words here, like substantial and materially, that give some latitude to a disciplinary authority that is assessing the lawyer's comments after the fact. Also notice that it's not a complete gag order or a ban on talking to the media completely, even if the comments favor the client's side of the case, especially if there's no reason to think that the comments could impact the proceedings. Now, before we move on, also notice that this applies only to the lawyers involved in the case. If you have a regular podcast or like doing media interviews, you're free to comment on other cases with which you have no involvement. Rule 3.6b continues and sets forth some statements that are basically always allowed unless an individual judge has imposed a gag order, despite the general rule in subsection A. We call these types of provisions in legal rules a safe harbor clause or provision, things that are safe to do without incurring liability or punishment, and 3.6b is one of those. It says, notwithstanding paragraph A, a lawyer may state, and it's going to go through a list here. 1, the claim, offense, or defense involved, and, except when prohibited by law, the identity of the persons involved. 2, information contained in the public record. That's almost always okay. And 3, that an investigation of a matter is in progress. So it's always okay to give comments to the media about what the case is about overall in terms of the nature of the claim or the charges, potential defenses involved, like is the defendant planning to raise the insanity defense or invoke some sort of legal immunity, and the identity of the parties. It keeps going, though, and has some more detailed permissions. A lawyer may state, for the scheduling or result of any step in the litigation, or 5, a request for assistance in obtaining evidence and necessary information that's necessary thereto. So it's always okay to tell the press things like when jury selection will occur, or that the court just ruled on a preliminary motion, or that you have filed an appeal. And then it keeps going. 6, a lawyer may state a warning of danger concerning the behavior of the person involved, if there's reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. And 7, in a criminal case, in addition to paragraphs 1 through 6, and we're going to have several more things. First, the identity, residence, and occupation and family status of the accused. 2, if the accused has not been apprehended, information necessary to aid in apprehension of that person. 3, the fact, time, and place of arrest. And 4, the identity of investigating and arresting officers or agencies and the length of the investigation. Now, these last few are just for criminal cases. Students often find some of these surprising. For example, that the prosecution can announce the home address of the defendant and their job and whether they're married or divorced and so forth. But one consequence of being arrested is that you do not have a privacy right in the fact of your arrest or the following prosecution. And yes, this means that you could still suffer some social stigma and reputational damages, even if the charges are later dropped or you're acquitted or the case is dismissed. On the other hand, this also helps avoid cases of mistaken identity. For example, after the awful mass shooting at a concert in Las Vegas in 2017, once the name of the suspected shooter was released, reporters around the country mistakenly pestered more than 30 innocent people in different states who happened to share the same name as the shooter. Identifying which John Smith or Mary Jones has been accused of a crime can help avoid these misunderstandings so that innocent bystanders who just happen to have a similar name aren't affected by it. Rule 3.6 continues with Section C, which says, notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. You may remember several years ago there was a tragic case where a young man named Trayvon Martin was shot and killed by a self-appointed neighborhood watchman or vigilante named George Zimmerman. The case attracted national media attention. The prosecutor in that case held a press conference that, honestly, I thought was intended to be inflammatory. In fact, I thought when I watched it that the prosecutor was violating this rule, even though I'm not a fan of George Zimmerman. The prosecutor made it sound like the defendant had committed cold-blooded murder. So soon thereafter, George Zimmerman's lawyer obtained and then released to the media some video footage from the jailhouse where the defendant was taken after his arrest. And it appeared to show Mr. Zimmerman looking a little scuffed up from a fight. He had some cuts and bruises. Because they planned to argue that when the defendant had confronted the victim on the sidewalk that a scuffle or fight had ensued, and the defendant claimed he shot his gun in self-defense when he was being injured. And this, for purposes of our rule, is exactly the type of thing that the rule contemplates. The footage was released only in response to the other side holding a rather inflammatory press conference to try to offset the damage that had been done. And now, so note that a media statement or an interview could be a proper response even if the opposing counsel has not spoken to the media. If, say, the media is already covering a case and presenting a very one-sided view. A statement made pursuant to this paragraph, it says, shall be limited to such information as is necessary to mitigate the recent adverse publicity. So, in other words, just because the other side has created a media frenzy about the case, you don't have freedom to say anything you want just because the other side has opened the door. Your statements should be limited to the minimum necessary to counter what has already been disseminated to the public. Let's move on to Section D. No lawyer associated in a firm or government agency with a lawyer, subject to paragraph A, shall make a statement prohibited by paragraph A. In other words, you can't get around this rule by just having a colleague from your office or firm talk to the press as your proxy. That would still count as a violation. Now that concludes this video about Rule 3.6. In a separate video, I'll discuss one of the important comments to the rule, which previously was a section of the rule itself that lists some topics that are almost always off limits, the opposite of a safe harbor provision.